Can everyone see and hear me? We have everyone nodding in agreement. Very good. We're going to get started. All right. Thank you. This is the matter of Nazir versus Nancy J. Pinkin in her capacity as clerk of the County of Middlesex. It is L 186322. Today is April 18th. It's approximately 2 o'clock. I am Judge Toto, and I am in courtroom 202 today. All the parties and counsel are appearing virtual. I am in court with my court clerk and law clerk. Counsel, may I have your appearances, starting with plaintiff's counsel.
Good afternoon, Your Honor. This is Yael Bromberg of Bromberg Law LLC on behalf of plaintiffs Atif Nazir, Herbert Tarbous, Ralph Johnson, Stacy Berger, and Jonathan Powers. And I have with me my counsel.
Good afternoon, Your Honor. Good afternoon, Your Honor. Brett Pugatch, of counsel to Bromberg Law LLC.
Great, thank you.
Good afternoon, Your Honor. Nikki Athanasopoulos, First Deputy County Counsel, appearing on behalf of the Middlesex County Clerk, Nancy J. Pinkin. And I also have her present in my office together with the Deputy County Clerk, Deborah Braga.
Thank you. We also have the request to intervene counsel. Would you just identify yourself since you're appearing?
Yes. I'm sorry, Your Honor, I was muted. Ronald Baruti of Marino and Baruti on behalf of Rick Maida and his campaign, seeking to intervene herein.
Yeah, I want you to be part of this. I don't know if I'm going to rule on that today, and I don't even have counsel. Quite frankly, I glanced at what you sent. I've been busy reading the submission that's been received. And I don't know, has County Counsel had a chance to review the request to intervene?
I'll be honest with you, Your Honor, very, very briefly. I didn't spend any considerable amount of time reviewing the merits of the petition.
Okay. So let's get started with this. I have questions for both sides, but let's start with plaintiff's counsel. I've read everything that's been submitted. What is it you'd like to tell me today? Ms. Bromberg.
Your Honor, everything was submitted in writing to you. I think this is a very simple case. This is about the definition of joint in joint petition as contemplated by the statute, 40 years of case law in New Jersey.
Let's stop right there. So because this really applies to both sides, where's the support for how I'm supposed to interpret joint petition?
Your Honor, joint petition is not specifically defined in the statute. What we do know from the statute is that it contemplates where you have multiple candidates that should be drawn as a unit. We also have a published decision that's been upheld and referenced to by multiple courts in the state that contemplates a more expansive reading of joint petition when appropriate. For example, even when there's only one county commissioner, then freeholder, that's running for office. But in addition to that, we have multiple other references to how joint petition is interpreted across the state of New Jersey and should be interpreted. We have the New Jersey ELEC compliance manual, which I referenced in the filing. There it explains it applies where joint candidates are made up of 2 or more candidates in the same election running for the same office. It is also referenced in the petition filing instructions that accompany what is commonly referred to as the joint petition. And in those filing instructions and in the face of that, the first page of that, what is commonly referenced to as joint petition, there's no cross-reference to associate. There's other instructions on that document, but there's no cross-reference, for example, to associate that commonly referenced joint petition is only applicable in another form of a definition of joint when associated with another petition that's filing. There's no cross-reference to interpret the way in which the defendant county clerk now is positioning to interpret the joint petition. And this is a larger question about changing the rules as you go and making sure that candidates are properly notified. The way in which the defendant is trying to persuade Your Honor to determine the rules will actually not just have an impact in Middlesex County, but across the state, including in this particular election in Passaic and Monmouth County, but just generally also across the state. I looked at other county clerks, for example, Sussex and Bergen. They all similarly define joint petition as something that's a very common sense understanding, which is when candidates are filing a physical document jointly through association that allows for the voters that support their nomination to comprehensively, i.e. jointly, sign in support of those particular candidates. There's no other reference to a cross-reference to suggest otherwise. And it's also included, by the way, on the Middlesex Board of Elections website, where it specifically indicates to individuals how to be a candidate. And there it also provides for instruction for joint petitions when they apply in the situation which I've offered, Your Honor. There's no suggestion of any other term or way for candidates to even be notified, to understand that there might be a different way of interpreting this.
Ms. Bartley, how do you distinguish then the case of Irwin versus Flynn that's attached to the moving papers of the county?
So, as Your Honor is aware, those moving papers were filed around, I believe, noon or so earlier today. My understanding of Irwin v. Flynn, that's a case that involves a pro se petitioner, first of all. They were not represented by counsel. Second, there's the question about whether or not there was a joint petition was not the issue in Irwin v. Flynn. Irwin v. Flynn referred to the 2017 gubernatorial race, where there were multiple candidates, I believe 6 or 7 for governor in that election. There was a candidate, a gubernatorial candidate, who secured column A. The MCDO, through county clerk, Middlesex defendant county clerk, secured column B. And the plaintiffs therein secured column C, but because they did not associate with a gubernatorial candidate, they tried on the lower level offices to move over to column A. So the question as presented, in my understanding, in Irwin v. Flynn, did not have to do with interpretation of a joint petition. That was simply not the case. It referred to the situation where you have a statewide candidate and a ballot that's full, 6 or 7 candidates on the ticket. Also, that decision was not published. What's been submitted is a transcript, which we're left to interpret. And it was also lately filed. I asked defendant counsel last week for any type of legal support to offer, because I didn't want to have to file a lawsuit requesting the court to opine on the definition of joint, when to me, quite frankly, it's very obvious. And that particular transcript or even case reference was not offered in support of it. But the bottom line is that my understanding is that that case is completely different. It's where you have a statewide election. There's other sections of the statute that refer to how the ballot should be drawn, where you have statewide elections, and there's other examples of case law and just precedent in the state where you have a ballot that is full of a range of candidates, as opposed to what you have here, Your Honor. So to me, that particular decision is not particularly instructive, including in the situation where we have a published decision, Philin v. Shell, 1980 decision, which read the definition of 19:49-2 expansively to even allow a joint petition requirement to be satisfied where there's only one county candidate. And here that's not the case. We're asking Your Honor for a common sense interpretation of what joint means as everyone in the state understands it, rather than changing the rules as we go.
What of the county's position that the clerk is afforded discretion in determining placement and deciding the issue of joint petition?
The clerk does not have the discretion to change the definition of joint petition. The clerk has this discretion where there's a full ballot, such as in the case we just discussed, or in other cases, and But particularly here, we're talking about the definition of joint petition, what the statute specifically prescribes. And the statute is actually very clear. The other section of the statute is also very clear, 19:23-24, where it sets out a process of open governance and of transparency and of accountability by which you determine the ballot draw at 3 p.m. of a specific date. Cards are drawn, there's anonymity, there's a process that's put into place so that people feel that the drawing of the ballot is fair and an open process. And in fact here, 11/20/20, the day of the ballot draw, the rule again changed, and there was a sudden announcement that there would be no ballot draw, apparently. Nothing had really changed in circumstance or facts. By the way, Your Honor, I was preparing to file the briefs here by noon the same day, and I had to go back and edit everything because I didn't want to send chambers into a fire alarm drill where facts had to be changed and updated within the documents. And County Council was aware of that. I put them on notice of that as soon as that 11/20/20 announcement was made. They knew that this was coming. So Your Honor, the statute contemplates a situation in which the draw is conducted fairly, that individuals are assigned. This is if the defendant wants to interpret a more a novel what's being presented here, which is a novel definition of the concept of joint, at a minimum, at an absolute minimum, everyone that needs to be notified in advance so that they can participate on a fair and level playing field. It can't be last minute some definition is created that there's no indication in any of the FAQs, in any of the instructions, no state guideline, no statute, no nothing to suggest otherwise. We have to have a fair and honest ballot election. And by the way, the defendant candidate here, I sent the notification to them, the letter asking for further clarification. I sent it the morning of Monday, April 11 at 10 a.m. When I did not receive a response closing in on close of business around 4 p.m. that day, I was advised to call the deputy clerk. That's when I was notified that the clerk was abroad, but I had received no notification otherwise, no automatic response, I didn't know. And when I called and spoke with the deputy clerk to apprise her of the submission of this letter, asking for further clarity, because the prior letter to my clients was actually very unclear. It said, we're going to just apply it for joint petition candidates. There was no real explanation of whether or not they were to qualify and how that was to apply. And when I asked for further clarity, because I thought surely they're not interpreting joint petition candidates in this new way, I did not receive a response. I called because somebody told me to try the deputy clerk. So I called the deputy clerk at 3:45, 4 p.m. later that day. She told me that she had not received the letter, she had not been notified of it. She asked me to forward it to her. And that is how I ended up getting a response from the county clerk's office the next day on Tuesday. And of course, I ended up, having to process and manage this issue as is routine with election matters exponentially and edited accordingly. But this is a part of the problem, is these last minute changes where there's no notification. And what's being presented here is actually an effort to change the system of policy across the state of New Jersey in such a novel way. And by the way, at the last minute. We're not asking the county clerk because in fact she did not conduct her ballot draw on Thursday. So we're not even asking her to conduct a new ballot draw. We're just asking her to do the original ballot draw that she was supposed to do in the way that everyone understands across the state of New Jersey it should be done.
It's probably a good spot to turn to the county council. And, I questioned why the ballot draw was not done, because it certainly appeared that it was anticipated.
Thank you, Your Honor. The plaintiffs in this matter were previously advised on April 8th that based on the submissions that they provided to the county clerk's office, that the county clerk would honor their request to be grouped. And subsequently to that, on April 12th, they were further advised that they would be placed in column B. It was the county clerk's office that was awaiting for the certification of the Secretary of State regarding the certification of the candidate for the U.S. House of Representatives, that at that point in time is when they determined that a draw would not be necessary, consistent with the previous representations to the plaintiffs in this matter. Counsel's, indication that that the county clerk waited to the very last minute is not accurate. The plaintiffs were on notice that they would be placed in column B. And as such, and based on the certification of the Secretary of State, the county clerk, in exercising her discretion, and based on the nominating petitions that were submitted, made a determination that a draw would not be necessary. And to further that point, Your Honor, and consistent with, the statute 19:49-2, which is controlling in this matter, and as I further indicated in the written submissions, plaintiffs claim that the county clerk's understanding of the term joint with respect to the interpretation of that statute is, grossly contorted, when in fact, the plaintiff's interpretation of that statute is misplaced. The statute clearly provides that all candidates who file a joint petition with the county clerk of their respective county shall choose the same designation, shall be drawn on a position of the ballot as a unit. Here, there's a statutory presumption that it must be a full slate of candidates consisting of fully bracketed candidates for a full complement of the offices in order to be eligible for the draw.
So in that interpretation, you're telling me that every spot has to be filled in order to be considered joint?
In order to be considered a fully bracketed petition, correct.
Where's the support for that?
Well, it's by implication of that statute. And the county clerk, in exercising her discretion and based on the petition's past practice, the advice of county counsel, and that of counsel of the Constitutional Officers Association, based on their direction, is that a fully bracketed, fully slated, full slate of candidates is subject to the draw. In this case,
what are the cases then that counsel submits indicating that there's been less than a full bracket where it's been acceptable to have a draw? It's at page 2 and 3 of her report. Oh, it's the letter to the county clerk of April 11th.
just one moment, Your Honor. Again, Your Honor, as I previously noted, counsel is hung up on the term joint when it is the county clerk's position, and we maintain that in order to be considered a full slate of candidates, there has to be a candidate named for each of the open offices. And in exercising that discretion, and based on the submissions of the parties, the clerk made that determination that in this case, the plaintiffs did not only did they not have a full bracket for county commissioners where they only had 2 out of the 3, but they also did not have a candidate for the position of the sheriff. And for that reason, the county clerk made a determination not to conduct the draw as there was no one else to draw against. And to further that point, Your Honor, and based on the submissions provided, for illustrative purposes, I provided the court with draft ballots that were prepared over the weekend by the county clerk's office. And the reason, and based on the submissions, what the county clerk attempted to do is to try to at least articulate and present to the court how, if the relief was granted in this case, and if hypothetically a draw was conducted with the plaintiff candidates, and if they were to draw column A, it would create some voter uncertainty, voter confusion, in that based on wards 1 through 4, that several of the columns would be blank. And under county commissioner, where it says vote for 3, there would only be 2 candidates running for those 2 positions if the plaintiffs were to be placed in column A. And for that reason, as I've previously stated, the county clerk exercised her wide discretion, which is highly supported in all the case law provided, that a draw was not appropriate in this case.
You attach Irwin versus Flynn. Judge Bergman heard that matter.
Yes.
Are you arguing that that is on point to this issue?
I am, Your Honor, in that the facts of that case are very analogous to the facts in this case, in that notwithstanding the type of election that was being held at that time, which was in fact a gubernatorial election,
Right.
the issue is still the same, in that matter, the Central Jersey Progressive Democrats were challenging the fact that they were not subject to the draw. And regardless of what positions or parties or candidates were listed, it was the same position that the parties are maintaining here, that they should have been eligible to be subject to the same draw. And as Your Honor could see, based on Judge Bergman's ruling, and specifically from what we can glean from the judge's opinion, pages 70, 74, 75, and 76, the judge clearly states and repeatedly references that a partial slate of candidates are not eligible to be drawn for ballot position. And based on his interpretation of the statute, he denied the plaintiff's relief in that case, and they were not subject to the draw.
Talk to me about timeframes that we're dealing with now, because we're running short of time.
Yes, we are. So hypothetically, Your Honor, and I do have both the county clerk and the deputy clerk here for that specific reason. Timing is of the essence. Ballots were supposed to be sent to the printer today, with the commencement of ballots to begin on April 23rd. And most importantly, are the ballots that need to be sent overseas. And the county clerk, by federal mandate, has to certify that those ballots were in fact mailed by that day. So, with all that being said, the absolute latest that ballots can be sent to the printer to be printed, and we're talking based on the certification of the county clerk, there's 111,246 ballots that have to be printed. So if I could just defer to the county clerk's office to speak to specific timelines with respect to that, Your Honor?
That's fine.
Okay.
Or for the mailing of the Uakava voters, which are the
Hold on one second. Your Honor, can you hear
Yes.
Deborah Braga?
Yes.
Okay.
which are the uniformed overseas civilians. Since that deadline would be April 23rd, we would need to send to the printer at least those ballots by Wednesday, so that we can receive them back and begin to mail them overseas. I would say probably the same that day or the following day, the latest, to begin the commencement of mailing for the in-state and the out-of-state voters, which we have to mail, like council said, 111,000.
Okay. Very good, thank you. Anything else?
Your Honor, may I be heard?
I'm sorry, who said that?
Ronald Baruti.
Mr. Baruti, in what capacity? Because you're here for the intervener.
Right, we're here for the intervener, but in light of the timing issues, and the court has indicated you may or may not hear my application, this is an emergent situation, and there's some facts I think that are important. We're actually seeking a mandamus. We think that there is absolutely no room for discretion at all based upon a normal statutory interpretation, which is the plain language of a statute. And the plain language of the statute says joint. Black's Law Dictionary, 5th edition, joint means united, combined, undivided, done by or against two or more unitedly, shared by or between two or more, coupled together in interest or liability. The plain language of joint doesn't mean a full slate. That's what
Well, that's the issue. That's certainly the issue. The question is, what's the answer? And there's not much out there that leads me one way or the other.
Look, respectfully, Your Honor, our position is there's nothing to interpret. Joint is the plain reading of joint is two or more people, two or more. There's no, the county council's attorney said a full slate in our argument. There's nothing in the statute that talks about a full slate. It just says joint.
I agree with that. You're right. There's nothing in the statute that says every line needs to be filled, and you're correct. I certainly could not find it. But in the same token, nor can I find much that defines, in terms of case law, what joint is.
I respectfully, the plain meaning of the word joint is all that matters. Our case law provides that when interpreting statute, we go to the plain meaning. We look at the plain meaning of the word joint. I just read the definition from Black's Law Dictionary. It's as plain as possible. Two or more is a joint application. Our case also is a bit different. We did not get notice, as I understand it, that there is not going to be a drawing. And also, we do have a congressional candidate at the top, so we're particularly prejudiced here by not getting the drawing. They're claiming that they have to have these ballots printed by Wednesday. That's an absolute emergent situation. I respectfully assert that Your Honor has the ability, given that what appears to be a flat-out violation of law by the county clerk, the court has the discretion to impose equity here and to change the date from April 23rd so as to give appropriate time for the public to receive notice, for the drawing to occur, and then the ballots to be printed. Otherwise, our clients are being deprived of their rights, and equity should not aid a wrongdoer. And that's exactly what would be happening here with the county clerk's actions.
Thank you. Ms. Brumper, did you want to respond?
Yeah, I mean, Your Honor, we're asking you to just simply apply the definition of joint. The clerk has no discretion to create a new definition. The legislature has been clear in its statutory instructions that you have joint petition. There's nothing to suggest a more robust interpretation of joint, especially one that would require a full slate in order to have a seat at the draw. There's no suggestion of that. So, Your Honor, there is every indication actually of how to, respectfully, of how to interpret the definition of joint and how it applies here. And it's the instructions that the defendant county clerk has provided to the candidates herself that were actually removed within 24 hours after I had revisited the website for some reason. It's their own instructions to the candidates. It's their own FAQ to the candidates. It's the way New Jersey ELEC interprets and notifies individuals of how to apply for joint. And again, there is actual history here with MCDO, the Middlesex County Democratic Organization. It's not the case that they always get line A necessarily. Last year, my understanding is that they got line B. My understanding is in the past, they've also received line B. So these last minute kind of concoctions again, when candidates run for office, they have to be put on notice of what the rules are. If we're going to say that we live in a democracy, everyone needs to know what it means when they run for office, when they're drawn on the ballot. It can't be that the rules shift or change, that a definition as basic as the word joint can change by happenstance without providing notice to anyone, and certainly where there's not any examples of anyone else in the county doing this. There's not any examples of the county themselves having done this in the past. I asked for legal authority last week. I received none. Again, Your Honor, the last thing I wanted to do was present to the court this question of joint because I thought it cannot be that they're interpreting it this way. And lo and behold, they are. And a part of this has to do with also the posture of the case, which is why in the verified complaint, I offered a little bit of context of who these plaintiffs are. One of them previously ran against the county clerk, who herself was a beneficiary of the MCDO line herself. So again, what we need for our democracy and our election system to be fair is at a minimum for people to be put on notice of what the rules are in advance. That notice, that new definition of the word joint is not found anywhere. No one has been, even if we can put for an argument for another day the constitutionality of the overall question, should joint petition be read within the statute through this novel way that's being presented? I would argue, Your Honor, that that's actually an unconstitutional interpretation of the statute, but that's not what we have to litigate before us today. What we are litigating is that the clerk herself does not have discretion to create a novel and new use of the term joint petition. If the legislature wanted otherwise, the legislature would have indicated it. The legislature has indicated a system in which if there are higher term candidates that are running for statewide office, such as gubernatorial or otherwise, that there is one way of doing it. If there's candidates that are associated with county office that submit a joint petition because they're jointly associated on the same physical copy that the voters all submit and sign for, otherwise we wouldn't have the ability. It actually makes sense if you're running for office, for the same office, that there's a position in which you can circulate to the voters a process by which the county commissioners jointly associate with each other, and the voters that jointly associate for that jointly support candidates that are running together as a unit for the same office can all sign. Otherwise, when they go door to door to get their voters to join their nomination, they would have to ask the voter to sign 2 or 3 times to support candidates that are jointly associated for multiple vacancies for the same office. If we were to interpret joint more broadly, then the template form that was created, that circulated, would allow for multiple offices to be listed on the same ballot. So there's a system and there's a reason that the system exists. There's no reason to interpret otherwise. And these are template forms that are circulated to the candidates by defendant county. If they wanted joint to be interpreted as you have to run for sheriff position and for county commissioner or for whatever elections are open for that particular race, they would design the petition form differently for each candidate, or at a minimum, because if you'll notice, and I submitted the forms, Your Honor, they're, I believe, Exhibit B to the verified complaint. If you actually study the forms, you'll see that for the county commissioners or for the county sheriff, etc., it's the same form. You just fill in the name of the office, but there's only option to sign 1 office, and there's up to 3 lines. And then when you flip, you see the voters can identify, there's instruction when the voters support multiple candidates for the same office to fill multiple vacancies, that they identify, I'm supporting this unit of candidates, right? And then when you flip to the candidate's affirmation, I am a resident, et cetera, there's an instruction. If you're filing this joint petition, that certification by the candidate, it doesn't allow for 3 forms for multiple candidates. It only allows for 1. In other words, you have to copy that form and you have to submit it because you're associating yourself as a joint as of 3. And the voters are supporting those 3 as a unit together. If there was an intention and a process, and I want to also focus on this thing of the 3 because it talks about the efficiency of the system, that the voters don't need to sign the same form 3 times for multiple people who are affiliated, jointly affiliated. If we were to interpret the design the same way that the county defendant is offering, then the template form would allow for multiple offices to be listed so that the voters can sign for all of the individuals, for all of the offices on the same form, but they don't. They're separate forms for separate offices. And there's no instruction to indicate otherwise, an association between both types of petitions. So it's the system in this way makes sense. And there's instruction provided to the voters and to the candidates. You can't simply change the rules as you go. We live in a democracy. There's got to be a fair system in place for all the candidates and all the voters to understand that there's a fair ballot design being construed. To the extent that the question about the unconstitutionality is at issue, Your Honor, we can argue that case, but that's not before you. What's before you is this basic concept of joint.
Thank you.
And again, my understanding also is that in the 2020 race, that the MCDO candidates and the defendant clerk designed the ballot such that they have column B, and that involved a presidential race. So you had a presidential race at the top of the ticket, and my understanding is that certain independent candidates in that race secured column A. This notion that the presumed winner of column A, you cannot change the rules as you go. That's not what democracy is. And the statute would indicate otherwise, the FAQs would indicate otherwise, the form of the joint petition would indicate otherwise. There would be a cross-reference between the two forms, and there isn't. And in fact, even more sensible, there would be one form that allows for multiple offices, but that's not the situation that we have before us, because this is a last-minute radical change that actually threatens to have statewide impact. And it simply does not make sense, Your Honor.
Thank you. County Counsel, last word.
Thank you, Your Honor. The county clerk just submits to the written submissions, which, is substantive and comprehensive with regard to the issues that this court has to consider. And just to further emphasize the point that, the county clerk does take objection to the fact that, we concocted this last minute and that we changed the rules to cater to, specific needs. That is completely and wholly not accurate, Your Honor. The county clerk has exercised this discretion, as I've adamantly reflected on the record, and this has been the custom and practice, which has been consistent with past practice and based on the advice of counsel and that of counsel of the Constitutional Officers Association. The plaintiffs have failed to establish that they would suffer any irreparable harm if the relief was not issued. And in fact, it is the voters of the county of Middlesex that are prejudiced and will suffer immediate and irreparable harm for each day that the clerk is restrained from preparing and mailing the ballots for the primary election. And with that, Your Honor, the county clerk submits that the county clerk's determination must be given great weight by this court in deference to the county clerk, since the plaintiffs have failed to establish that they are entitled to the relief that they are requesting herein.
Your Honor, may I just add one other comment?
Yes.
Thanks. Your Honor, I'd just like to refer the court to the case of Jersey Central Power and Light versus Melcor, 212 NJ 576.
Give me one more second. Give me that again, please. I'm sorry.
Jersey Central Power and Light, JCP&L versus Melcor, 212 NJ 576. It's a 2013 case. I'm going to read from the case. In performing the duty, our search begins with the plain language of the statute. The court must look first to the plain language of the statute, seeking further guidance only to the extent that the legislature's intent cannot be derived from the words it has chosen. The statute's words deserve to be given their ordinary meaning and significance, and a court may not presume that the legislature intended something other than that expressed by way of the plain language, which is exactly the point. Again, the word joint, as defined by Black's Law Dictionary, we presume that the legislature understands the terms they're using, is united, combined, undivided, done by or against two or more united, shared by or between two or more, coupled together in interest or liability, joint, two people or more. That is not the way that the clerk has interpreted it, but the clerk has no right to interpret. The plain language speaks for itself. In this case, we do ask once again that Your Honor permit us to intervene We do have some different facts that are, and we'd be very prejudiced if there's a ruling against us in favor of the clerk without her intervening. We do have a congressional candidate at the top. We do have 3 commissioners who invited the candidate to be part of the bracketed slate. We only have 1 position missing from the bracket, and we didn't get notice at all that this drawing was not going to happen. So under the circumstances, we respectfully request Your Honor to permit the intervention and to direct by mandamus that the clerk conduct this ballot draw after giving appropriate notice to the public with as much immediacy as possible, so that our clients are not prejudiced by the county clerk's illegal act. Thank you.
Thank you all. I will have a decision for you by tomorrow. Have a good night.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.